Hello everyone and welcome to another episode of OK Law. I'm Kim Kiat and today I am the Senate. Now I am the only one here today because Simon is on MC. So today we are going to be talking about the charge. Not the 冲水 kind of charge, but rather we are talking about charging someone with a criminal offense. This is the real beginning of a criminal case. Now, you may ask, what's the difference between a normal case and a criminal case? A normal lawsuit and a criminal lawsuit. In a normal lawsuit, one guy sues another guy. But in a criminal case, the offense is considered so serious and so bad for society that the state will come and sue you. Let's say my friend Jerry kena charged with a crime. Will he be allowed to defend himself? Of course. But then, he first has to know the details of what he's been charged with. The judge must tell him exactly what offense he's been accused of. Section number what? Of the whatever code or the whatever act. The time and place of the offense. Who he committed the offense against. If not, it's just like you try to plug Apple cable into a Samsung phone. Means what? Means you cannot charge lah. So now, Jerry knows what he's been charged with. Next step will be to find a lawyer lah. The lawyer Jerry gets will be called the lawyer for the defense or defense counsel. Why is he called defense counsel? It's because he is counseling the defense. Obviously, right? On the other hand, the lawyers representing the state are called the prosecutors. An individual prosecutor is called a deputy public prosecutor or DPP for short. All of them combined make up the prosecution. All the prosecutors come from this special law firm, which isn't actually really a law firm. It's called the Attorney General's Chambers or the AGC. And their boss is called the Attorney General. How come leh? Because it's the Attorney General's Chambers lah. The Attorney General is not an army general. He will not make you do push-ups. You can call him the top lawyer in Singapore. Okay, in Singapore, we have what we call the adversarial system of law. This just means that there are two sets of lawyers who fight each other as adversaries when they present their cases in court. Yeah lah, it's a bit like a boxing match lah. So what about the judge or the judges? They will listen to the lawyers present their cases. Then in the end, they will make a decision, just like a referee. The judge will not go and help present the case for either side. Everything is up to the lawyers. As I said, the judge is like a referee, he's not a fighter. So last time, we mentioned this thing called a jury. Actually, since 1969, Singapore no longer has a jury system. This is how a jury works. It's made up of random ordinary people. Then the lawyers will try to convince the jury that this or that thing actually happened. Let's say, someone was seen stabbing Simon to death. Jerry is accused of stabbing him. If the prosecution convinces the jury that Jerry stabbed Simon, then the jury will find that Jerry is the someone who was seen stabbing Simon. This is called a finding of fact. In Singapore, the judge performs the function of the jury. So the lawyers are actually trying to convince the judge. The judge can therefore make findings of fact. He or she will also talk about how he thinks the law will apply to the case. This is called a finding of law. And then, after the case is over, the judge will go to the car park and make a finding of car. Okay, so who decides when to charge somebody with a crime? The answer is that the prosecution will decide. Article 35, subsection 8 of the Constitution says that the Attorney General ultimately has the power to charge somebody with a crime. But of course, he is not going to do everything himself. He will just arrow the prosecutors under him to handle the case. And that's why we have the term prosecutorial discretion. Because the prosecution can choose when to charge somebody with a crime. Even a judge cannot choose for you. Too bad. So sad. Now that the accused person has been charged, what's going to happen next? Under Section 23 of the CPC, he will have a notice read to him. In this notice, he will be told that he has the right to remain silent. And then, if he decides to say something, his statement will be taken. This is called the caution statement because it has a caution in it. Here's an example.
Jeremy Gunn, you have been charged under Section 300 of the Penal Code. Do you want to say anything?
Okay, pause. In this situation, three things can happen. 1. Jerry can plead guilty on the spot. This means that there will be no trial and he will be sentenced. 2. Jerry chooses to act blur and keeps quiet. However, as we mentioned in the last episode, there is this thing called the adverse inference. This means that the fact that Jerry kept quiet when asked to make a statement can be considered as super sus by the court during the trial. And that's why acting blur doesn't always mean you live longer. 3. Jerry chooses to speak. If he does so, he'll be expected to outline the main parts of how he wants to defend himself. This doesn't mean he must suddenly turn into a lawyer and come up with all kinds of powerful law arguments. It just means that, for example, if he got into a fight because he was drunk, he has to say he was drunk. Normally, if Jerry decides to say something, then it usually means that he doesn't want to plead guilty. And that means he wants to get a lawyer and have a trial. That's going to be so much more exciting. And now you may be wondering, what happens at the trial? Check out the next few videos to find out. Okay, let's summarize. When someone is charged, it's like the state is starting a lawsuit against him. He must be told all the key details about the offense he is being charged with. The state's lawyers are called the prosecution, and the accused person's lawyers are called defense counsel. They will fight with each other in court as part of the adversarial system. And the idea is from this, the truth will emerge, and this will allow the judge to reach a good decision. Singapore doesn't have a jury system, so the judge is the one making both findings of fact and findings of law. The prosecution also has a discretion to charge someone with a crime. They will take into account all kinds of factors to do so. After the accused person has been charged, he can choose to keep quiet at the risk of having an adverse inference drawn against him. He can also choose to plead guilty. If he pleads not guilty, then there will be a trial. Hey, steady lah. I can also be a lawyer. See you next time.